In 30 seconds, we are a bit ahead of time, so let's start smoothly. First of all, welcome to this press conference by the European Data Protection Supervisor. As usual, we will have a speech of about 20 minutes. We will do it in a way of asking questions and having answers, and then we will give the floor to you so that we will have, let's say, 30-40 minutes to discuss your questions. So on my left, we have Supervisor Giovanni Buttarelli and the Deputy Supervisor Wojciech Wiewiórowski. So we will start now. And my first question will be for you, Giovanni, if I may. 2018 was the most important year for EU data protection in a generation. With the GDPR and the new regulation for the EU institutions in place, are the rights of every individual living in the EU better protected than ever? What is your opinion?
That's true. And 2019 would be even better. 2018 hit the headlines worldwide, and you see to which extent this is relevant under different viewpoints. Let me thank you for being here. I see some usual suspects, but also new faces, which means that data protection is attracting attention. And indeed, data protection is increasingly on top of the political agenda. You have seen today the Justice Commissioner, Mrs. Jourova, discussing about future possible relationship with India right after the establishment of the bigger de facto trade area in the world in between EU and Japan, which was fully based on a data protection assessment by both the European authorities and the Japanese. So we celebrate today not only the 5th annual report of my institution, which is in charge of supervising around 70 European Union institutions and bodies, agencies, offices, larger scale databases, but also we're approaching the first anniversary of the GDPR. There is a little bit of unfinished work, which relates in particular to the e-privacy zone regulation, one element which should particularize and complement the general data protection regulation in the area of electronic communications. The Romanian presidency has issued yesterday a new compromise text, which is a little bit controversial according to some capitals. We really hope that the Romanians will succeed before end of June to get consensus in Parliament. There are important discussions worldwide on what it means, e-privacy, the regulation for the European industry on artificial intelligence and industry. But on top of last year and this year initiatives we are trying to lead, we have an enormously interesting discussion on the intersection in between data protection, consumer protection and privacy via, in particular, the digital clearinghouse. You have been familiar with the decision of the German antitrust authority concerning Facebook. It's time to now discuss about the future architecture of data protection at Europol, the European Union FBI, Eurojust, which is likely to be reinforced, the future European Public Prosecutor Office. All these networks will be under the lens of Wojciech and I. But this year, more than ever, the emphasis is on where we are in terms of citizens' rights and on the impact of data protection on everything other than the rights to personality, in particular to democracy. I said many times that the Cambridge Analytica case was, still is and will be only the peak of an iceberg because of a certain dominant business model. You see the sanctions to be applied everywhere, not only in Europe. And we are concerned, notwithstanding the establishment of a reinforced networking between data protection authorities and the European institution focusing on the fairness of elections, that this year we have a challenge to allow all political parties and movements, those who are pro-Europe or to leave, not UK, but Europe in this case, to have a fair and open access to new technologies, new means to communicate. We don't want to slow down the right to be informed and to inform, but there is a challenge in between of fairness, equal access to sources, online manipulation, fake news, hate speech. And so this is our daily food, and we will, Wojciech and I, be very happy to satisfy all of your concerns today.
My second question will go to you, Wojciech. The European Data Protection Supervisors is the EU Data Protection Authority. So the EDPS supervises all institutions, bodies and agencies in the EU. What do we have to report here when it comes to supervision?
Yeah, definitely the supervision of the EU institutions, bodies and agencies is a core activity of the European Data Protection Supervisor, and that has been an important year for that as well. As you precisely know, at the end of the year we had a new regulation on the EU, on the data protection in the EU institutions, bodies and agencies, so-called Regulation 725 from 2018, which was passed in autumn, but it immediately came into force and it is fully applicable from 11th of December last year. And of course, we've been preparing for that already for years, knowing the main principles of GDPR and knowing the new institutions that were introduced by GDPR and the new ways of protection of the citizens' rights, we've been able to prepare with the institutions to this new chapter. In your package you will find the infographic on all the accountability road that we made with these institutions throughout last 2 years. You also will find a list of different trainings, but also the other kinds of activities that we did, the podcasts, the video messages, which were both directed to the top management of these institutions, but also to those who are working there, and what is the most important, to those who are the clients of the EU institutions. So we wanted them to be prepared on the day one and to be really leaders by example, because there are not too many institutions, there are not too many offices and bodies, but each and every mistake they will do will be very well visible, and unfortunately it will harm the overall picture of the reform of the data protection law in Europe.
Giovanni, let's come back to you. We are facing big challenges when it comes to data protection. We have discussed that before. You are approaching the last year of your mandate, so we would like to have your views about the future, the immediate future of data protection, and even beyond GDPR. What would be the challenges at that level, data protection and privacy global?
The last year of this mandate is exciting, as well as the previous and perhaps the future. I can go through a shopping list to trigger your curiosity, but data protection is increasingly horizontal, and it affects a lot of public and private activities, and there are many issues to be discussed. I mentioned trade agreements, and we have now 132 countries growing every single day in the world with a new generation of data protection provision, not privacy, data protection. Some of them are very similar to GDPR, others are GDPR-like, GDPR light, but it means that the well-known debate which took place for more than 20 years, regulation versus self-regulation, is over. Even in the US, now they realize in a bipartisan mode that it's time for a federal law to privacy after the efforts in California and in the Washington state to have new provisions at at state level. So trade agreements and therefore free flow of data internationally, cybersecurity, not only by criminal viewpoint in terms of prevention, repression of crimes. An additional protocol to the Budapest Convention is under revision. Here we may speak about judiciary and police cooperation, but also about how we make our new society more secure in a moment where we're moving definitely and finally to what was originally manual, then automated, and now fully electronic. So the availability, integrity of information used for many public purposes is at stake, particularly now that we are developing an Internet of Things world where machines will exchange data with other machines without involving us. Artificial intelligence and big data are part of the so-called fourth industrial revolution. They are already a reality. And therefore we are building the values for the future. Digital ethics. I said at the last and perhaps most successful ever conference on data protection of all privacy and data protection commissioners in the world. We gathered 1,446 people from 80 countries. We got messages from heads of state and government. It never happened. Why? This is not because of Wojciech and I. This is because of the growing importance of data protection. President Putin said 1 year ago, the one who will succeed in having the data and in processing them, he was referring to AI and big data, will take it all. So data protection is not only rights to personality, but increasingly, and not only the oil of the modern, let's say, business model, but it's power, it's balance of interests. So we would like to see how now binding principles such as privacy by design and privacy by default will be relevant for the rest of the world. GDPR is in some way extraterritorial, meaning it is applied here to everybody staying outside Europe, profiling people here remotely, or offering goods and services remotely. So today we are largely discussing with the US, Silicon Valley, but by 2021, once the Chinese market will better penetrate us, it will be another challenge. So this is why Wojciech and I has been requested to act internationally, to be a sort of an EU ambassador of data protection, to be in full cooperation with national data protection authorities, to be efficient in providing the Secretariat to the European Data Protection Board. That's a mission in which Wojciech and I succeeded. I have some figures to share with you. But to conclude, since I said we would like to be very short, we are looking to the past, we are managing the present, we would like to defend and better implement the present in the near future, but we already started by thinking to the long-term future. GDPR, consumer protection, antitrust provisions cannot succeed, even though they will start be used in a non-silos perspective. There is an issue about the digital dividend. There is an issue about the balance of powers. There is an issue concerning the dominant business model, how it affects the modern society. So we're not evangelists, we're not Taliban, but we would like to orient the European data protection framework in a way which may allow for better benefits for us. So this is why I've announced for around the first anniversary of the GDPR end of May after the European Union elections in any event, a visionary and ambitious manifesto looking to the future. The GDPR will not be changed before, let's say, 7 up to 10 years. Every discussion will take 3 up to 5 years and will enter into force in another 2 years. So the GDPR is likely to stay for roughly 20 years, which is more than a century today. But the future should be designed now, because it will change a lot. So we would like to offer our personal, though institutional, advice to the legislators, particularly right after the elections, to start thinking now how we would like to speak better with one voice, building on the pros and cons of the experience in EDPB, making profit of the excellent relationship we have with our sister authorities. But EDPS is the Data Protection Authority better placed to deal with the European Union interest, with the vision. And vision requires to be courageous, to speak the language of sincerity. So we would like to surprise you with some references concerning unfinished business, but also to design and identify the values for processing of personal data in 10 years from now. The society we are now approaching will be entirely different from now.
Good. That was very clear and short. I think that we have more than 40 minutes now to open the debate, to discuss a bit with you. So I propose that you ask your question by introducing yourself first and then asking your question, and then let's see whether we take one or two in a row. So who would like to start? Jennifer.
Jennifer Baker. You spoke this morning to the LIBE Committee in the Parliament, and I understand you talked about Privacy Shield and how perhaps it's an instrument of the past. What would replace it? What's wrong with it? And, do we just let data flows stop flowing, or do we rely on specific clauses for specific cases if it was to be thrown out?
Well, going back to the predecessor of the Privacy Shield, Safe Harbor, you know that we have been pushing for something else, but we have been successful in modifying the original proposal by the Commission. And once the text has been adopted in 2001, before 11 September, we have been working for years to make these legal instruments effective in practice, which was not the case. The Safe Harbor has been in dead waters for years and years, notwithstanding the various recommendations. And because of the Snowden case and because of the also decisions adopted by the heads of state summit in 2013 and 2014, the Court of Justice was forced to say we have not enough reassurances about the use of this data for purposes other than the commercial. So it's very strange, and this is identical for both Safe Harbor and Privacy Shield. So data are transferred to the US from companies in Europe, could be European or but also American companies, for a pure commercial interest. But then there is a big appetite by law enforcement bodies to have a routine access to this data. And this has been clearly declared. Okay, this is legitimate, so each intelligence service, each law enforcement system should be effective, should spy on people subject to certain safeguards. So the privacy, the Safe Harbor has been killed because of the lack of transparency about this kind of data. And the Privacy Shield is partly a lesson learned. There are many improvements on the commercial part. It's much better than the Privacy Shield. It is not the one of my dreams, but I cannot say the commercial part is against the EU legal framework. There are some gaps, a little bit of vacuum, reassurances, but perhaps a strong implementation can be helpful. So I can only recommend the new administration to continue working positive with us to provide reassurances, because we have been waiting for reassurances, not criticizing. And we're not asking anymore. We're not asking the moon. We're simply asking what is in the Privacy Shield. So to satisfy the curiosity about the conditions, the prerequisite for having such an adequacy finding. The discussion is a little bit more difficult concerning surveillance. And here we should be frank, candid, since there's a paradox. On the one hand, the Privacy Shield is the most democratic exercise worldwide in terms of transparency of what intelligence services do. I've never seen anything similar around the world. There are annexes saying how they spy on you. And this is because of the importance of data for law enforcement and intelligence purposes. But the way in which they do it is perhaps legal in the US, but not exactly in conformity with our values. No, we may have different requirements because of the rulings of the European Court of Human Rights, but also because of the Lisbon Treaty, the Charter. And therefore, should you want to use the data, my data, the data which are processed here for your purposes, okay, give me some reassurances. That's the mantra. And what we got was, let's say, interesting but incomplete. And I'm not a lover of the bureaucracy about the ombudsperson, the State Department, plea club. I understand that we have a different culture, although they should ensure that the newly established ombudsperson should work shall act at least independently, although by legal viewpoint is not entirely independent by the European Union viewpoint. So we've been dealing with two consecutive joint reviews. We are waiting for new signals. We appreciated some efforts. Others may come. But now the ball is in the US part. We still need of certain reassurances about the use of data for law enforcement purposes. And with regard to my analysis, I see that now US will start thinking about the federal law. It will take 4 years, not less. So privacy, let's consider the Privacy Shield as an interim instrument looking to the past and not to the future. It has been adopted before the GDPR. The GDPR provides for maintenance, but also for an assessment, regardless of the joint reviews, which would come. But my comment was that now that GDPR is applied to everybody working remotely in the EU, profiling people, offering goods and services, the mere operation to provide safeguards for the transfer of data is a little part of the story, because a company subject to the full scope of the GDPR should respect the GDPR in its entirety, and not only when the data are transferred and when they may use the Privacy Shield. So it's an acceptable legal instrument, provided that is fully implemented, but with the US as a strategic partner, we should work better together to prepare the future. And if you look to the Japanese, sorry for being so long, to the Japanese adequacy finding, you see some improvements compared to the Privacy Shield. Once again, this is not the perfect deal. We've been looking for improvements. Others may come with regard to the implementation of the Japanese adequacy finding. But in terms of use of data for legitimate law enforcement purposes, you have more than in the US. It's a question of reassurances. I'm not blaming them for what they do in practice. It's a question of clarity. If you sell a house, you would like to have some clauses, and therefore the question is which clauses are in writing, which reassurances can be reinforced.
Thank you. Another question? Yes, thank you.
Just to follow up on that, when you say you'd like more assurances, what specific assurances do you need about the surveillance? And if you could just compare what happened with the adequacy with Japan to the privacy shield, why are there more assurances in the Japanese adequacy decision?
The answer is largely, though not entirely, on what you mean for bulk collection. The US have been very transparent in saying we do bulk collection of data, and the approach is different, provide that depending on the target, US people, non-American people, and so forth and so on. And we say, okay, we do not take care what you do internally with regard to American people. Question is about us and about the use of data transferred from the EU. And we had a discussion which was also new for us and will be new also for the European courts, both, about the consistency, conformity, acceptance by a legal viewpoint of the notion of bulk collection as applied to EU data, EU citizens. Someone started by saying it is fully incompatible, so bulk collection is as such incompatible with the EU system. Others say you may have a temporary bulk collection, you may have a targeted bulk collection, you may have a periodical bulk collection, and perhaps right after the bulk collection you don't retain the data, and perhaps bulk collection in a limited number of cases is indispensable, no? When you don't know the target. So my vision is that bulk collection as such is not fully incompatible with our system. The question is, once they say we do bulk collection, could you better specify what you mean for? That's the main question. Then we had a change in the administration, so I understand that it has been difficult for the new administration to consider privacy as a priority. To my surprise, they started with very negative declarations against the privacy shield, but then companies say, no, don't touch this. And therefore the new administration started by working on it, and a few days before the visit of the EU delegation, they did something very interesting, I should say. We need to continue working.
Next question.
Particularly, sorry, if they want to prevent another safe harbor case. So these reassurances are not only needed because Wojciech and I are insisting, our colleagues, but because the privacy shield will be soon under the scrutiny of the Court of Justice. Should they would like to have the privacy shield in place, the safe harbor agreement should be a lesson learned.
Mehreen Khan from the Financial Times. On the US angle, but a slightly different one, I'm wondering if negotiations over the Cloud Act have come into your radar. And we know that the Commission has asked for a single mandate to be able to carry out these negotiations against what I think the Americans had planned. Does any of what we've already seen, what will be included in the Cloud Act, raise any red flags about cooperation with US authorities and obviously access to servers in Europe? Is this something that, when we talk about the future, is something that we have to consider now?
Well, this is a complex dossier. US Cloud Act is a legitimate, though unilateral act dealing with an international issue. Let me speak for a second as a member of the judiciary with a background on organized crime. Cooperation is needed. This is why, for instance, they are updating the Budapest Convention, which has been a failure in terms of international cooperation, sharing of data, freezing of data, joint inspections and remote inspections and so forth and so on. So the entire architecture, including access to data retained abroad by data controllers and providers and processors not subject to entirely to the national jurisdiction, should be designed in a new way. Some provisions of the Cloud Act may be considered as controversial against the GDPR, while Europe is approaching an important similar dossier on e-evidence. So the interplay between the two will be key. So a solution should come. So I welcome even the criticism against one of two. There are different table proposals, and I contributed with an important opinion. I doubt this will be a dossier for this mandate for the European Parliament. So discussion will continue.
Thank you. Another question? Jennifer?
Somewhat related to that, I just wanted to ask you about data retention. I mean, it was struck down by the ECJ, but various countries have gone ahead unilaterally within the EU to implement sort of new data retention rules. Your own country, Italy, is well known. I just wondered, could you comment on that?
I was already touché this morning when Mrs. Inveld was forced to say that it's a big mistake. There are many non-democratic countries in the world which spy on people, and they have no need to retain the data for 6 years. 6 years is not sustainable. That's it. Right after the 2008 decision of the Court of Justice, there are efforts by some member states to go back to the glory days where data retention of traffic data was not subject to any time limit. But I see that in Germany and many other countries it's now a question of weeks. Let me go back once again to my background as member of the judiciary. In an important summit in Newcastle by all heads of police national offices, it was very clear that the appetite is around the last 6 months in terms of investigation. So the freezing of data and the German approach, for instance, speaking about weeks, could be helpful. I do not believe that the Italian system, because of mafia, Camorra, and 'Ndrangheta, would justify such a long approach. Neither Pol Pot or Gaddafi or Ceausescu entered into such a long system. So I really hope that the new parliament will have time to go back to this issue, to allow Italy to continue being a leader by example. In the meantime, the Romanian presidency has tabled a new version of the e-privacy regulation, and by surprise there is an article, I guess the 11th, allowing national member states, I do not believe this is an issue for the privacy regulation, to introduce data retention periods to pursue a legitimate public interest, so beyond law enforcement. Okay, it is not the 1st of April, but I can accept it as a contribution to the debate. But I hope they will sleep on it and consider that the ruling of the Court of Justice can be addressed to national laws as well, not only to the European legislation.
Good. Another question? I've got one for you, Wojciech.
Yes.
Yesterday, the EDPS published some guidelines about proportionality. Can you explain us why it is so important to speak about proportionality, why it is important now in this debate, and what is the interplay between proportionality and necessity?
Well, necessity is definitely the first thing which we assess when we are dealing with any kind of limitation for the human rights and for the citizens' rights, and it's said precisely that it's possible only when it's necessary. So no, not at the moment when it's economically feasible or logical, but necessary. But when you pass the test of necessity, then you have to decide, is the intrusion really proportional to the effect that you can get? And there are two dimensions of that. The first dimension is how far you go with the intrusion. The second is how effective is the result of what we get. That was a famous discussion that we had during the PNR regulation and the whole discussion about introducing the European PNR system. Having at the same time the discussion about anti-money laundering. And I've been asked several times by senior members of the European Parliament who said, why you are so critical about PNR and at the same time you allow anti-money laundering solutions. And our answer was because anti-money laundering solutions are proportional. They are proportional because you can show the effects. You can show that you are leading to the effects to be reached. While with PNR, it's at least questionable if any added value exists. So the discussion about proportionality is the whole story of preparing any kind of legal solutions that would limit the access to the rights of the citizen. And on the other hand, we decided to prepare the guidelines for that because sometimes we are accused as data protection authorities, not only on European level but also on the national level, that you always say that something is not proportional. That's so easy to say that it's not proportional. So we decided to make it part of the toolkit to help the legislator to assess the proportionality of the measures that they are going to prepare, but also the drafters and also those who are then implementing such regulation, how to deal with this delicate balance between achieving the goals that are probably the ones that we want as a society. On the other hand, not make the intrusion into privacy rights too far.
My Polish twin was saying that beyond consent and other legitimate grounds, all processing of personal data in Europe are lawful, provided that they satisfy the necessity and proportionality test. And necessity doesn't mean usefulness. It means the existence of a social pressing need to achieve, as he said, a goal. If you don't satisfy the necessity test, the processing is unlawful. And then you move to proportionality to see in practice how to be balanced. And this is why the two documents the last one for public consultation, are pragmatic. So they are relevant for national and European Union legislators. Could be relevant when you install a CCTV system and you have to decide whether to use zooming or retention of data, the list of people having access to the information, and so forth and so on. Necessity and proportionality have been underestimated till today. So thank you, Olivier, for the question.
Another question? Yes.
You mentioned before the Cambridge Analytica case, Untitled Chapter. By the way, I was wondering what would be the impacts of Brexit on your job and on the data protection?
I continue to put my money that ideas will come. You see that now they are speaking about possible second referendum. I do not interfere on what is purely national in UK, but Brexit is not only an issue for one member state, because the impact is huge. This is why within the EDPB we have agreed with all other 28 national DPAs, including ICO, the Data Protection Supervisor in UK, to have a sort of memorandum for companies to be prepared in case of a no deal. So while transfers from UK to the EU will continue without any panic, the opposite situation will be a little bit more difficult. So imagine in 1 month from now you will have no good developments, no extension periods. Well, as from midnight of March 29, in between March 29 and March 30, UK will become, by data protection viewpoint, a third country. And this is regrettably a divorce. When there is a divorce, you may have, let's say, decent relationship. You remain a friend, but no more than a friend. No more than a friend. So you're not anymore a member of the family. You cannot say, okay, we stay at home and we continue joining with you what you do, what we did in the family. It's another family. Divorce means another family. Brexit means, by data protection, Brexit. So they have to then, so companies will have to, in an interim period, transfer the data from the EU to the UK by using standard contractor clauses, binding corporate rules, certification mechanism, and in a limited number of cases consent. But then a solution is to be found. And this solution, unless politicians will be so creative, unless UK will be part of the European Economic Area or EFTA, who knows? Different options will be available. But perhaps an adequacy finding is to be the only way. It will take years. And then we have to assess the necessity and proportionality of the UK intelligence system, which is very powerful, and this will require years. So I respect all the sentiments of those pushing for leave, but I think by data protection viewpoint is not convenient. So it will be difficult, particularly for companies. It would be a big challenge for many legislators. We are at disposal, but I do not have any crystal ball. I can predict what will happen, but I'll tell you off the records.
And we have to remember that there are the parts of the British Empire which stays in the zone of adequacy, which are Jersey and Isle of Man, who have the adequacy finding.
Marianne?
Can I just follow up on the notion that it will take years to get an adequacy decision for the UK, because the Brits seem to be under the expectation that it shouldn't take very long, given that they are essentially a member state which is leaving on the day of full compliance.
Also signatories to the Council of Europe.
Well, the standards in the Council of Europe Convention and even in the modernized convention to be still signed and ratified are different compared to those in the GDPR. The Commission, I'm not the guardian of the treaty, so it's up to the Commission to have a strategy and their priorities in terms of negotiations. I understand and pay tribute to all the expectations, but other countries are queuing from years. Mexico, India, Mrs. Euro said this morning, South Korea, and many others. 130 two countries, I said, now are interested to have an adequacy finding. It means that we should now stop working on GDPR and simply work for them. The adequacy finding requires a lot of work. Even if they are fully compliant, because the GDPR is currently applicable there, question is will relate to all the pictures indispensable to be assessed, including the surveillance part. And because of certain judgments, I perceive that it will take time. I'm not saying it will be difficult, but this is not an issue for tomorrow. So a divorce, regrettably, is a divorce, and it means that you need of time before re-establishing certain relationship.
We have to remember also about the other challenge, which is which Commission is facing. By May 2020, European Commission is expected to prepare the report on international transfers under GDPR, which includes the information about transfer to the third countries according to adequacy agreements, which actually stipulates that by May 2020, European Commission should make reassessment of the currently existing adequacy decisions, at least to prepare the report on how the laws of countries like Argentina, but countries like Israel as well, or Switzerland, are in compliance with the new regime which exists in Europe. And the deadline is in the GDPR.
Anyway, Brexit will affect the way in which we work together within the EDPB. But we remain sister authorities, will not affect the way in which I cooperate with one of my best colleagues, Elizabeth Denham and ICO. They are a distinguished DPA. We cooperate within different areas, the Spring Conference, the international one, the Enforcement Subgroup International, GPAN, bilaterally. There's a lot of expertise. They supported our exercise on digital ethics. The Berlin Group, IPAN, so many other fora will be available. But cannot say today that they will be in a position to join EDPB even as observers, because this will depend on the big picture. In case of a withdrawal agreement or a no deal.
But you're not ruling it out?
Sorry?
The observer request from the ICO, it's not...
Yes, I'm very familiar with. We had the discussion at the last EDPB plenary. EDPB is equipped with some rules of procedure to provide to provide any sister authority with the status of observer, but this is linked and dependent on the big picture. And there is a reference in our rules of procedure with regard against the big picture. So we have to understand first what happens. I put my money that nothing will happen for a couple of years, but this is my personal prediction. Provide that they go for an extension period. How many days we are looking for? 30, 33? So we are, to use a football language in my country of origin, in the Cesarini area. No? It was a famous football player of the 50s. He was not a brilliant one, but I don't know why he scored in the last 5 minutes every single time, and this is why this area is now so famous.
It's follow-up on the same thing.
Other questions? Perhaps one. Every day in the press we have articles about Chinese tech companies wanting to invest in Europe, convince Europe that they do very well on data security, that they can compete with US companies. We have some fight back from the US side. What would be your opinion, Giovanni and Wojciech?
Olivier, I said good question, not burning questions. Huh? No, I'm joking, and I'm so happy you touched this point, since I have invited the rotating chairman, I think this is the correct job title of Huawei, currently in Barcelona, I guess, to have a meeting with us after the first round of declarations we gave, and after the interview I released days ago. We are, as data protection authorities, entirely distant from the wrestling in terms of trade agreements. And so we don't want to be manipulated and to have data protection manipulated for purposes other than protection of personal rights. Second, Huawei, as well as any other Chinese provider and any other provider in the world, should offer safeguards in terms of proper use of the data and in terms of integrity. So there is no difference in between Huawei and others. They are distant from us. They come from a country which is a complex one. The Chinese authority would like to start discussing with us how the GDPR is impacting their activities. Perhaps now, because of certain difficulties in terms of working languages and softwares, they're not in a position to massively offer goods and services in the EU or profile people in the EU. So GDPR will be gradually a reality. But we have been told that by 2021, at the very latest, they will invade the market by also processing of personal data viewpoint. So it is worth to have a dialogue, not to isolate these authorities. And I say, I am concerned. And I say, why? I am concerned because of the rumors. Every single country should cooperate with their law enforcement authorities, but perhaps this cooperation will be stronger in some countries than in others. So we're not having a debate. This is why I've accepted their offer to be a couple of days in the headquarters in China and to visit this country. It will be my first time. So I'm waiting for this meeting to clarify that we are honestly available to give a contribution to this transparency, which is also essential in terms of cybersecurity, integrity of the data. So one question relates to cooperation with national law enforcement authorities in China. And the second question is integrity of the data by a security viewpoint against cybersecurity.
Wojciech, what are we doing at EDPS to monitor the new technologies and to tackle the issues, the challenges that these new technologies can bring when it comes to data protection?
2018 was the year when we started to rebuild our possibilities as far as the IT is concerned. We have upgraded the sector that existed in the EDPS to the level of the unit. We have also the new head of this, at the same time having the special advisor who is dealing with the new technologies and helping us to understand them. We are also going to employ the special people whose role would be to understand the market of the data analysis, and who will be able to show us the challenges that we have to face in the nearest future. Well, we try to be present at these places where the discussion about the artificial intelligence, but also the blockchain, also the new post-cloud solutions are going on, and we try to transfer it not only to legal language, but most important to the level of the organization of the IT systems. You may probably remember that in the strategy which we prepared at the beginning of this term, we put one of the objectives that the data protection goes digital. It doesn't mean that the data goes digital because data went digital 40 years ago. It means that the law is not enough. What actually is ruling right now the data protection is the way that we organizationally deal with the data in the IT systems, and this is actually the thing which the EDPS is the most interested in at the moment as far as the IT things are concerned. We are also quite active in the European Data Protection Board, and with the discussions about the guidelines on the blockchain, use of blockchain, not only for cyber currencies, because the cryptocurrencies is only the one of the field, maybe the most the active at the moment as far as blockchain is concerned, but also in the other areas and the other sectors when this technology is present at the moment.
So right after the first data scientists we recruited, others will join us soon.
Yeah, just to follow up on what you were talking about with the Brexit in the UK. You mentioned about companies facing some difficulties, and I was just wondering if there are specific industries that might have expressed some concern. I'm thinking about financial services companies, insurance companies, companies that are dealing a lot with personal data transfers.
As far as I know, those more concerned are those having particularly, but not only in the financial sector, more than one establishment in the EU, and therefore they've tailored their system to have ICO as the lead authority. So they have now different options to move outside the UK, to move the main establishment in the EU, or what else. Not easy. So there is currently a limbo because nobody knows what would happen. It's incredible. I see the difficulty of the debate. So we can only be in a waiting mode. The GDPR provides for long-term solutions with regard to the flows of data from UK to the EU. Provides for some instruments about the other way around, but for long-term, this is not sustainable for a country so linked to the EU and interested to have a close relationship by internal market, financial market viewpoint. Not speaking about the chance, about missing the chance to continue working within the EDPB to define certain practices, certain safeguards, requirements. So once you are out, it's more complicated.
So unless there is one last burning question, I don't see that. Some announcement. The first one, of course, is to thank the two supervisors for their time, for their answers to your questions. Thank you, audience, for being here with us. Don't forget to take the press pack, because in it you have some nice promotional materials by the EDPS. You have also a nice USB card with the publications that we released today, which is the annual report and the summary executive annual report. And something I'm very proud of, what Sheikh mentioned it about everything that we have been doing on guidance to EU institutions, bodies and agencies when it comes to data protection rules. There is a fact sheet. There is a very nice infographic on all the trainings that we gave. Please read it. It's really interesting. We have the new head of supervision and enforcement here, so she's one of the cornerstone to this new policy. And then please take this as well. Supervisor Buttarelli has mentioned the international conference. It was a huge success. I'm sure you have been following that, but there is the conference report is available. Very nice document. Please take one
free of charge for you.
Free of charge, obviously. And then the last announcement that I will do in the line of what Giovanni said about digital ethics, we will launch a new series of podcasts. We start next Thursday with a third postcard at 9 a.m., if I'm not wrong. It will be published also on our website, where we start a series of 6 discussions about digital ethics. So please stay tuned. My whole team is here. You can ask them. They will help you, and everything is online on our website. So thank you very much.
Have a nice day, and thank you for joining us.